is present from his office, and present from the, I'm going to have to mute the courtroom there. All right, and present from his office is Mr. King. Now, Mr. Armstrong, you and your client both agreed to conduct this hearing by Zoom rather than in-person presence in the courtroom.
Yes, we are.
You're all right with that, Ms. Blow?
Yes, Your Honor.
All right, now since you're not in the courtroom sitting next to your attorney, if at any time you need to talk to him, you just let me know. I can put the two of you into what's called a breakout room, and you can talk with each other with no one else hearing your seat.
Your Honor.
All right, the record reflects that the defendant was convicted of aggravated possession of methamphetamine, a 5th-degree felony, placed on community control on December 20, 2019. There was notification filed on November 12, 21 that she had failed to comply with conditions of community control. It alleged that she had violated Rule 2 and she had failed to report to the Hyden County Probation Department on 7/29, 10/7, 10/25, and 11/4 of this year. Rule 3 that she moved from Hillsborough to Louisiana without permission. Rule 13 that she has failed to enroll and complete any recommended aftercare. Now, that was filed by Officer Kelly, who's also present for the session from her office. Mr. Armstrong, have you had an opportunity to review these allegations with your client?
Yes, Your Honor. We spoke in person this morning, and Brittany is prepared to admit the violations of Rule 2, 3, and 13.
All right, Ms. Long, the offense which you were convicted is a 5th-degree felony which carries a possible prison term between 6 and 12 months. Your sentence originally was placed on community control. In the event it is found that you have failed to comply with those conditions, whether it be by your own admission or through a evidentiary hearing, which is what this is set for, one of three things can happen. I could continue to community control under the same conditions previously ordered, continue with additional conditions I think are appropriate, including extending your probation or community control for an additional 2 years. Or the third, the most serious, that could revoke your community control and send you to prison for between 6 and 12 months. Now, you do have a right to have this hearing and have your attorney cross-examine witnesses that the state presents. You have a right to have him ask questions, and once they're done, that's a cross-examination, which is designed to help bring out evidence and help your side of the case. You may present any testimony or evidence on your own behalf, although you're not required to do so. Now, you understand the allegations, and the notification was filed on the 12th.
Yes, Your Honor.
And you understand the possible consequences if you admit to the violations.
Yes, Your Honor.
Has anyone promised you anything or threatened you in any way to get you to admit to these violations?
No, Your Honor.
Okay. Do you have any questions at all then about the consequences or potential consequences of what's going on here today?
No, Your Honor.
All right, then, do you admit the allegations that I just read to you as filed on November the 12th by Officer Kelly?
Yes, Your Honor.
Anything from the state or the probation department regarding this position?
Yes, Your Honor. The state would ask that the defendant be continued on community control, ordered to complete substance abuse treatment, and also referred to drug court. It's clear that there's a pretty serious substance abuse issue going on here. I'm looking at a drug screen from November 14th. The defendant was positive for amphetamine, marijuana, buprenorphine, and also fentanyl. So that's obviously very concerning. It's the recommendation of a drug court referral. That's all I have, Your Honor.
All right, Mr. Armstrong?
Brittany readily admitted to me that she had had a relapse, and she'd been clean for, I think, about a year. She would certainly welcome the opportunity to do additional treatment when she told me that's what she would like to do, and would welcome drug court. The only thing that I would point out to the court, I'm not independently verified, but I don't know what she told me, is that until I think it's 3:30 today, she does still have her job at Aristide. So I'm not sure what the drug court policy is about employment, if you encourage it or discourage it at the beginning of drug court, but She has an apartment, I believe. She's got a car payment, and she disclosed on her financial form that she is employed in everything too. And I don't know how she knows if she still has the job. The court can inquire of that, but I think if she admitted to me that she relapsed, has a problem, wants additional help. But I'd certainly like to be able to see her keep that job if at all possible.
Long, anything you'd like to say?
Your Honor, I did relapse, and I want to take full responsibility for my actions. I spent 1.5 years building a life that I love, and I've worked at ARC for over 1.5 years, or over a year now, and I'm in quality. So I've been moving up. I just need treatment. Like, I need classes. In second shift, I'm gonna change shifts because I feel like second shift is just a hard shift to do anything. I go to church and I also attend meetings, but once I started that second shift, it became void, and then I was putting work before everything else, and I need to learn how to balance everything together so I can stay sober.
So your job right now is on second shift?
Yes.
Well, how's that going to stop you from doing exactly what you did? You said you blamed it on the second shift that you relapsed. So we want to send you back to work at the second shift.
I plan on definitely either looking for a first shift job or asking them to move me to third shift once I go back. I talked to my coordinator, and that's how I had perfect attendance, and that's the only reason why I've not lost my job yet. But I'm out of my vacation today as of today, so if I don't make it today, then I won't have my job. But I do plan on moving to third shift or even getting a different job.
When did you get out of Star?
I got out of Star not last April, but the April before.
Yeah, you were there from Clayton County, right?
Yes.
Are you still in community control there?
No. I actually made Star Plan of the month. I went to Field of Hope upon leaving Star, and I was there for 3 months. And then upon leaving there, I come back. I was going to be in FRS, but they had opened a Phoenix Center in Wilmington. And at the time, it was for women. So I just wanted sober living. And so I went and I stayed there for almost 4 months, got a job at ARC, and I've been working and taking care of my daughter. And then, like, I had my daughter all summer long, and my mom, once school started, she went back to my mom. So I just, I messed up, and I can't change what I have already done, but I can change how the future is going to be.
Did you ever complete residential treatment anywhere else besides Star?
Just the Phoenix Center.
Okay. All right. Well, it's your report that your good control be continued with the additional conditions. I'm going to refer you to drug court, and you can talk with the drug court coordinator. This person is actually on the call. I'm going to order you to complete, be assessed for residential treatment and complete any treatment that is recommended. I'm thinking that you need to go into a residential treatment, but I'll leave that up to Ms. Sturgill and the evaluators to determine. The job is important, but on the other hand, it just goes to show having a job doesn't keep people sober. And in fact, in your case, you're blaming it for your relapse. So I think that's a little convenient. But the fact of the matter is that you didn't follow up on treatment, you moved, you weren't reporting. So, if that's what a job means to you, it means you violate community control, then that's not the job. So you're probably going to lose your job because I'm going to order you to be in jail until you're accepted into the treatment program. And Ms. Sturgill, your impression, you think this is probably a residential treatment situation?
Either that, sir, or perhaps even Clean Acres in Clayton County.
Sure, or sober living. Okay. All right. So until you're accepted into a treatment program, you'll remain in jail, and then once that's arranged, whether it's a residential treatment or sober living, then you can be released to that program. Your community control will be extended by an additional let's see, you've been in since 19, you've already got 2 years, or not quite 2 years because it was told, but close to 2 years. So, going to extend your community control for 2 years, and in case you do get into drug court, if you don't get into drug court, that could be subject to be terminated early, depending upon your progress. All right, anything further from council?
No, Your Honor.
All right. All right, that'll conclude the hearing then. Thank you. All right, are you Desiree Lynn Griffith, or is it loud?
It's Griffith, Your Honor.
All right, Griffith. All right. It's case number 20 CR 137. State of Ohio versus Desiree Lynn Griffith. That's appearing by Zoom from the jail. Her attorney is William Armentrout, appearing by Zoom from his office. Assistant Prosecuting Attorney King is appearing by Zoom from his office. Armentrout, you and your client are both agreeing that this matter may be conducted by Zoom rather than in person in the courtroom. You're all right with that, Ms. Griffith?
Yes, Your Honor.
All right, this is an evidentiary hearing on a alleged violation of community control. The defendant was convicted and placed on community control, looks like on October 8th, 2020, on 3 counts. 2 counts of trafficking and heroin in the vicinity of school, 4 felonies, and 1 count of aggravated trafficking and methamphetamine in the vicinity of school, 3 felonies. Now, there was a notification filed on November 16th alleging that Ms. Griffith had violated the conditions and that she has failed to report to Huntington County Probation since March 9 of this year. She failed to enroll in complete substance abuse treatment as directed, and she still owes $499.50 in clerk reports for court costs. She was advised of that alleged violation, I believe, by the magistrate. Mr. Armentrout was appointed representative. That was set for a hearing today. And Mr. Armentrout, you had an opportunity to review these allegations with your attorney, or with your client, I'm sorry.
Yeah, Your Honor, we went over in person earlier today, and Desiree has told me that she's prepared to admit to the violations of Rule 213 and 15.
All right, Ms. Griffith, you do have a right to have a hearing in this matter, which the state's required to present evidence that proves that you have committed these violations as alleged. You have a right to have your attorney cross-examine the witnesses the state presents to try to bring out evidence that helps your side of the case. You have a right to present evidence and testimony on your behalf, although you're not required to do so. In the event that it is found that you have failed to comply with these conditions, whether you admit to that, or whether that's the finding of the court after evidentiary hearing, one of 3 things can happen. Your community control under the same conditions previously ordered. Your additional conditions that they are appropriate, or the third, most serious, they can revoke your community control and like a total 72 months in prison. In addition to fighting you $15,000. You understand that?
Yes, Your Honor.
Right. By the way, if you need to talk to your attorney, since you're not sitting with him in the courtroom, just tell me and I can put you in the breakout room where the 2 of you can talk alone and no one else will be able to see you, okay? All right. Now, you have any questions about the allegations?
No.
Do you have any questions about possible consequences?
No, Your Honor.
You understand?
Yes.
Has anyone promised you anything or threatened you in any way against you to admit to these violations here today?
No.
And do you admit the allegations that were filed on November 16th that I just read to you? All right. This Felony from the Probation Department is on the call. Session follows drug treatment. The program is registered. Does the state or the Probation Department have any regulations regarding disposition.
Thank you, Your Honor. Given that this is the defendant's first community control violation, the state asks that she continue on community control and in order to complete star relapse, there is a bad day for her on December 8th. Thank you, Your Honor.
Mr. Armstrong.
And speaking of Desiree this morning, she read it, she realized it's just, like that. And indicated that she was in the prison with action. She was doing any other alternative.
Alright. You have anything you'd like to say, Mr. Cruz?
This may be crazy for me to ask you, but I do ask that, I think the other program would possibly a drug court or a fitness house on afterwards, just to help hold me more accountable, because I am serious about this time. I didn't get serious last time, I really want this time. I have my kids back in my life, and I just, it's my time to be a better mom. It's my time to be responsible for my ass and to be a better person. I'm not sure if you mentioned drug court or not, but I know I can more responsible. And so I really did make a difference. And I just want to do it. But that was my question. Battery down. How they can and how they're wrong.
They have the satisfactory coordinator and doctor to determine whether their cross out appropriate remedy and all that is great. That's something that you need consider, but I can't order that without a doctor determining that that's what's appropriate. It's still up to you. Where do you live?
I live in Greenfield, Wyoming.
Alright, you say that Billy, the bid is available December the 8th?
Yes, Your Honor.
Alright, was the order of the court, Mr. Strickland, that you be continued on paid control with additional conditions? First, that you're complete the start relapse program. Second, you, and recommended aftercare, and that's where the MAD come in. You're to be held in jail until December the 8th, which time you'll be conveyed to STAR. And I am going to refer your case to the drug court coordinator. Ms. Sturgill is on the call to determine whether or not you wish to apply to be, and whether or not you're qualified for that program. And if you wish to, and you file that, then the court can address that after you file your application. And you're paying the court costs. And let's see. October the date. 20, your control will be extended by 1 year. Alright, is there anything further, counsel?
Your Honor, I would just note that her underlying convictions are for trafficking, so she's not eligible.
Oh, that is right. That's right, I forgot. So I can't do that. Yeah, so. Yeah, because it is trafficking. So the referral will be not eligible for that. But, you can't be evaluated, and part of the aftercare program, when you come out, you'll be assessed. And that certainly will be part of it, whether it's at STAR or if it's at FRS. They'll look at you and determine whether you need an MAT, which would be a Vivitrol shot or Suboxone or Subutex or one of the other medical treatments. All right. You have any questions, Mr. Griffin?
So I will be going to STAR December 8th and then aftercare afterwards, correct? With the extension by a year.
Correct. And they possibly will extend, what I'm thinking is should happen, again, it'll be up to the probation department and your counselors, is that should be going to a transitional housing program rather than going back to Greenfield, such as a youth center, the youth reentry center, or one of the programs through the council or through Pike Recovery. But again, that'll be up to them and part of your plan. All right. I think that's it. Then our next case is 215. So it's still in the same session. So we'll just I'll remain on this, and if you're going to remain on, just put your mic on mute. And 215 we'll be back with Miss Barber and her client.
Your Honor, those are both pleas. I don't know, you don't have the plea form with you.
I do have the Preston plea form.
Okay.
It was, somebody scanned it in, so he scanned in the other one, Mr. Wilson, and, send it to Miss Hoyer, and she can, forward it to me.
Ms. Lawyer has that plea form right now.
Oh, okay, alright. Then would you tell Marcia, then would you get that, tell her to get that scanned in and, sent to me, and I can screen share it?
Will do, Judge, I emailed that.
Yeah, because I got to work with you, as a background, just
Judge,
feedback from the, speaker system, when I have that in my notes. Alright, I'll see you by 2:50.
okay. I emailed both pleas to you, Judge, let me know if you
Okay, Judge.
Is case number 21 there? 148 state addresses. Gabrielle Preston. And are you Gabrielle Preston appearing there on the screen? It is marked Lindsay Thomas.
Your Honor, I am Gabrielle Preston.
All right. Preston is represented by Sarah Barber, who's appearing with this hearing being conducted by Zoom. Here on behalf of the state is Assistant Prosecutor Adam Cate, also Mr. Fulton from the Probation Department, as well as Mr. Arjima is going to be admitted here shortly also from probation. Now, Ms. Barber, you and your client both agreed to conduct this hearing by Zoom rather than an in-person court hearing.
Yes, Your Honor.
And that's okay with you, Ms. Preston?
Yes, Your Honor.
All right. Now I need to share my screen here, so like that. And all right. All right, Ms. Preston was charged with aggravated possession of a fentanyl-related compound and 5th degree felony. I know the matter is set for trial. I don't remember the date. But the date is set for a final pre-trial. And Ms. Preston, I was sent this plea of guilty form. Did you see that on your screen?
Yes, sir.
All right, those numbers at the top are when they were faxed various places, and then that was scanned and emailed to me to this computer. It says that you're going to withdraw your not guilty plea, plead guilty there to the first count of the indictment under 29, 25, and 2011. You see that?
Yes, sir.
Okay. Now we're going to scroll down to the end of this, and there is a page there, I believe it's page 3, and right there where my cursor is, it says I enter this plea voluntarily, and right below that there's a signature of defendant with a line above it and a date 11/30/21. Is that your signature there that I'm looking at under that sentence? I enter this plea voluntarily.
Yes, Your Honor.
All right. It says you signed it today. Is that correct?
Yes, Your Honor.
All right. And where did you sign it? Are you in a treatment facility?
I am, sir. I am at Ascend Recovery and Counseling in Portsmouth, Ohio.
Okay. And so did you fax that then to your attorney?
Yes.
Okay. All right. Now, did you go over this carefully before you signed it?
Yes. Yes, Your Honor.
And did you discuss this matter with your attorney before you got it and discuss the terms of the agreement with her?
Yes, Your Honor.
And I know you had a breakout session immediately before we started this record hearing. And did you discuss the matter with her to your satisfaction?
Yes, Your Honor.
And do you feel that you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
Are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
All right, now going back to the first page, as I said, it shows you're going to plead guilty to the charge under 2925.11 of the Ohio Revised Code, which is a 5th degree felony, aggravated possession of fentanyl-related compound, and it further states that you understand there that the maximum penalty could be 12 months in prison. The minimum could be 6 months if prison is imposed. It could be a fine of $2,500. There could also be a license suspension of 6 months to 5 years. You understand that?
Yes, Your Honor.
And are you facing any felony charges in any other jurisdiction?
No, Your Honor.
And are you currently on community control, probation, parole, or post-release control for a felony?
Nowhere but here in Highland.
Okay. That's just on the pretrial supervision.
Yes.
All right. Now, under the law, Ms. Preston, should you be convicted of this offense and should you be sentenced to a term of imprisonment, once that prison term is completed, it is possible that the adult parole authority may decide to put you under what's called post-release control supervision for a period of up to 2 years. That means you'd be supervised on the terms that the adult parole authority says because the court's not involved with that. If they determine that you have failed to comply with those conditions, they could return you to prison even though you served the entire term that was ordered by the court for an additional period of up to, in this case, 1/2 of whatever prison term was imposed for one or more violations. But if you committed a felony while under post-release control supervision, then in addition to whatever sentence the judge In the new case to impose that judgment also sentence you this case to initial period of 1 year, whatever time is left on that 2 years of post-release control, whichever is greater. That occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor.
Under the law, I'm not required to sentence you to prison. I can't impose what's called community control. Community control is what people know as probation. It means that instead of going to prison, you're supervised under the terms set by the court by a probation officer for a period of up to 5 years. Now, if during that period of time the probation department feels that you have failed to comply, then they would have to file a written notice of that with the court, serve a copy on you. You'd be entitled to have a hearing and be represented by an attorney at that hearing. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control, then sentence you to 12 months of incarceration and fine you $2,500. Do you understand that?
Yes, Your Honor.
All right, now, the charge in this case, as Preston alleges, that on or about March 6, 2021 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance to wit a fentanyl-related compound, in violation of Section 2925.11 of the Ohio Revised Code. So that's the charge, the felony charge, 5th-degree felony that we're talking about. Now, do you understand what you're charged with, what the state said you did, when, where, how they alleged you did it?
Yes, sir.
Do you understand the possible penalties for the offense?
Yes, sir.
Have you discussed the charge, the evidence in the case, the possible legal issues in the case, the possible offenses you can try to raise in trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with her advice and confidence in this matter?
Yes, Your Honor, very.
Have any threats been made to make you plead guilty here today?
No, Your Honor.
Now, are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs there at the treatment center?
I am, Your Honor.
What kind of drugs are you taking? Prescription?
Mental health meds.
Okay. Now, do any of those medicines interfere with your ability to understand what's being said here today, or to express your thoughts and respond to questions appropriately?
No, Your Honor.
Okay. Well, if there's anything you don't understand, just make sure you tell us, and then we'll go ahead and explain it further, okay?
Okay, thank you.
All right, now, there on the bottom of page 2, you'll see some, on your screen, some printed in bold and underlined and then partially stricken out. And it says there, defendant shall enter a plea of guilty to the indictment, state defense shall direct community control, and then written in substance abuse treatment. Is that your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that to get you guilty here today?
No, Your Honor.
The law, Ms. Preston, the matter of sentence is reserved to the judge, not the parties. And so even though there's an agreement that you should be sentenced to community control and substance use treatment, I'm not required to follow that. So if you plead guilty, once I've heard all the information submitted to me, if I decide that's not the correct sentence, I could end up sentencing you to prison for between 6 and 12 months, with finding you $2,500 and suspending your license for 6 months to 5 years. You understand that?
Yes, Your Honor.
All right. Now, you have certain constitutional rights you need to understand before I can accept the plea. Before I get there, though, do you hold any license or certificate from any state governmental agency for any occupation or profession?
No, Your Honor.
All right. Now, you have the right to have counsel in this case. Ms. Barber's appointed to represent you, not simply to work the case out, but to provide any defense that might be available to you under the law that you wish to provide. So if you decide you don't want to do this, that you want to stand on a plea of not guilty and defend against the charge, she'll continue to represent you, including in trial, if that's what you want. Do you understand that?
Yes, Your Honor.
Right, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens from this county that were subject to the jury duty at the trial date. After they were selected, those 12, the evidence would be presented, they'd be instructed on the law by the judge. Then that jury of 12 would have to have to decide by a unanimous verdict, being all 12 have to agree on a verdict, as to whether or not the state proved your guilt of the charge. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial, and in that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, it would be the judge who hear the evidence The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proving beyond a reasonable doubt. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you would have to come into court, testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney could ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps from your side of the case. Do you understand that?
Yes, Your Honor.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. So if you have any witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena, and that forces those witnesses to come to court and be able to testify if they want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, Ms. Preston, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't. You make that decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it, with one exception, which is if there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, Your Honor.
Right, now, under the Constitution, you have a presumption of innocence, which means that you cannot, you do not have to prove that you're innocent of these charges simply because you've been accused. In fact, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. But you're not required to try to prove you're not guilty. In fact, you don't even have to put on any evidence to trial. You could, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proving beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, originally you entered a plea of not guilty. Ms. Preston, your not guilty plea denied the allegations in the indictment, denied you committed any crime. That exercised or revoked all the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea would admit the allegations in the indictment, admit that they are a crime, and that you committed that crime. And that plea would waive or give up all of the rights that I've just described for you here today, except one, your right to have counsel. You always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty waives, gives up your right to have a jury or court trial. Waives, gives up your right to confront witnesses against you and to cross-examine them in open court through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, like the state. It waives or gives up your privilege against self-incrimination because you're the one saying you're guilty. That's what's used to find you guilty. It also waives or gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. Subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I should sentence you to the maximum sentence, then you could file an appeal, and under other certain limited circumstances, file an appeal. That would have to be filed within 30 days of your entry of sentencing being filed with the court. Do you understand all of that?
Yes, Your Honor.
And Ms. Preston, are you a U.S. citizen?
Yes, Your Honor.
All right, now, do you have any questions about the charge or the possible penalty?
I don't think so. Thank you.
You understand?
Yes, Your Honor.
Do you have any questions about the plea agreement?
No. No,
You
Your Honor.
understand?
Yes. Yes, Your Honor.
Do you have any questions about any of the constitutional rights that I've explained to you here today?
No questions, Your Honor.
You understand those?
Yes, Your Honor.
Do you have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
No, Your Honor.
You understand it?
Yes, Your Honor.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of the agreement that we've just gone over?
Yes, sir.
All right, then as to the charge, which alleges that on or about March 6, 2021 in Huntington County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, a fentanyl-related compound in violation of Section 2925.11 of the Ohio Revised Code, a fifth-degree felony, aggravated possession of a fentanyl-related compound, carrying a possible prison term between 6 and 12 months, a fine of $2,500, a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right. Court finds and on this date of the court was advised of all the constitutional rights made no intelligent voluntary waiver of the same pursuant to criminal 11, please accept the court file. Defendant found guilty of the charge as set forth in the indictment. The defendant's case to be referred to the Probation Department for pre-sentence investigation, which shall include an assessment for her substance use disorder and or mental health treatment and recommendation. Bond will be continued. Let's see, I don't have my sheet here in front of me, but I believe, let's see here. I'll find the sentencing date here. It's first Wednesday in January at 9 a.m. I believe that might be third.
Your Honor, I need a Tuesday or Thursday, please.
Oh, yes, that's right, okay.
I don't know yet.
Actually, that would be the first, but that's a Wednesday. Oh, wait a minute, I'm sorry, January. Okay. Ben, can you get the calendar there for me?
Okay, Judge.
And unmute there at the bench. Mr. Coleman, do you need any contact information for her while we're waiting on the calendar?
Yes, Your Honor. I do.
Do you give him the number there, Ms. Thomas, and who to contact?
Yes, for Zen Counseling, it's 740-876-8290. And my counselor is Heather Timberlake.
Thank you.
All right, Ms. Boyer, do we have time on the 6th to do a sentencing? Is that a pre-trial, a motion day?
Yeah, Ms. Barker's here at 2 o'clock for a Zoom.
All right, so we'll do it sentencing by Zoom, then at 2 o'clock.
6.
On the 6th?
Yes.
Yeah, January 6th at 2 o'clock. And bond will be continued. And Mr. Fulton will be in touch with you regarding your assessment.
Okay.
Yes, sir. All right. Anything further to counsel?
I don't think.
All right. Thank you.
He will.
Careful.
You can log off, Ms. Thomas.
Sorry.
All right, Mr. Wilson there, if you would unmute then, please.
Recording in progress.
You got a set up there, Ben?
Yes, sir.
All right. I'm going to go ahead and mute you because of the feedback.
Okay.
All right. This is case number 21 CR 173, State of Ohio versus Ryan L. Wilson. And you're Ryan L. Wilson appearing there on the Zoom box with Ryan Wilson in the corner?
Yes, Your Honor.
All right. Defendant's attorney is Sarah Barger. She's appearing by Zoom from her office. Mr. Prosecutor King is representing the state, appearing by Zoom from his office. Ms. Barger, you and your client are both free to conduct this hearing by Zoom rather than an in-person appearance in the courtroom. And you're all right with that, Mr. Wilson?
Yes, Your Honor.
All right. Now, the defendant's charged with theft by deception, a 5th-degree felony. And I'm going to share my screen here with everyone, and it should have a plea agreement there. There we go. You see that on your screen there, Mr. Wilson? State of Ohio versus Ryan L. Wilson with your case number?
Yes, Your Honor.
And, the plea of guilty form there says,
Yes, Your Honor.
now I'm gonna go to the last page, and that's page 3, and there's a signature, or there's a sentence right there by my cursor that says, I enter this plea voluntarily. You see that?
Yes, Your Honor.
Right below there, there's a line with a signature on it. Below is which printed signature defendant. It's dated 11/23/21, and is that your signature?
Yes, Your Honor.
And so you signed it a week ago.
Yes, Your Honor.
Well, where did you sign it? Ms. Barber's office?
We were at the courthouse, Your Honor.
Oh, at the courthouse? All right. And did she go over that agreement with you before you signed it, Mr. Wilson?
Yes, Your Honor.
And she explained everything to your satisfaction?
Yes, Your Honor.
Do you feel you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
You haven't changed your mind since last week?
No.
Are you entering in disagreement to plead guilty voluntarily?
Yes, Your Honor.
All right, now we're going to go back up to the first page. It says there that you're going to plead guilty to the charge in the indictment of theft by deception under section 2913.02A3, a fifth-degree felony. And then right below that, it says that you understand that the maximum penalty for that could be 12 months in prison. The minimum if a prison term is imposed is 6 months. Could be a fine of up to $2,500. You understand that?
Yes, Your Honor.
Are you facing any felony charges in any other jurisdiction, Mr. Wilson?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, Your Honor. Other than
Pre-trial?
pre-trial supervision.
Okay. Now, under the law, Mr. Wilson, if you should be convicted and if you should be sentenced to prison, once you complete the prison term, it is possible under the law, as part of that sentence, that the Adult Parole Authority could decide to put you under what's called post-release control supervision for a period of up to 2 years. That means you would be supervised by a parole officer in the terms that they set, because the court's not involved with that. And if they determine that you violated those conditions, they can return you to prison to make a short condition period of up to half of your prison term for one or more violations. But should you commit a new felony while under post-release control supervision, then in addition, whatever sentence a judge in that new felony case to impose upon you, that judge could also sentence you, in this case, to an additional period of 1 year. Whatever time's left on that period for post-release control, whichever is greater. If that occurred, that would have to be served consecutively as sentences in your case. You understand that?
Yes, Your Honor.
All right. Now, I'm not required by law to impose a prison sentence on you for this offense. I can impose what's called community control. Community control is what most people know to be probation. What that means is that instead of being sentenced to prison, you'd be put under supervision of a probation officer in a term set by the court for a maximum of up to 5 years. Now, if during that period of time that you're being supervised, the probation department felt that you were not lying, they would have to file a written notice of that with the court and serve a copy of it. You'd be entitled to have a hearing, be represented by an attorney at that hearing. If the outcome of the hearing was that you had failed to comply, then at that time the court could fine or could revoke your community control and then send you to prison for 12 months and fine you to $2,500. Do you understand that?
Yes, Your Honor.
Right now, the charge in the indictment, Mr. Wilson, reads that on or about July 17, 2021 in this county, you did with purpose to deprive the owner Shirley Blevins of her property, not only obtain or exert control over it, to win $3,200 in U.S. currency and other miscellaneous items by deception. The value of that property being greater than $1,000 but less than $7,500. So that's what's called theft by deception, which is a fifth-degree felony with the possible prison term of 6 to 12 months and fine of $2,500. Now, Mr. Wilson, do you understand what it is you've been charged with, what the state said you did, when, where, and how they let you get it?
Yes, Your Honor.
Have you discussed the nature of the charge, the evidence in the case, and possible legal issues in the case, possible defenses you might try to raise in trial, and possible outcomes of the trial with your attorney?
Yes, Your Honor.
Are you satisfied with her advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any type of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs?
No, Your Honor.
Now, has anyone threatened you to make you plead guilty here today?
No, Your Honor.
Right now, there on page 2, there's 3 lines that are underlined in bold, printed in bold, and then there's a couple of, there's a little change there and some initials. You see that?
Yes, Your Honor.
All right, so for the record, what that says is the defendant shall enter plead guilty to the indictment. State and defense jointly recommend community control substance abuse treatment. Defendant agrees to make restitution to Shirley Blevins in the amount of $3,413.04. Is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
And are you entering into this agreement to plead guilty voluntarily?
Yes, Your Honor.
Now, under the law, Mr. Wilson, the matter of sentence is up to the judge, not to the parties. So even though the state and you and your attorney are recommending the same sentence, that is committing control of substance abuse treatment, the court is not obligated to follow that if you plead guilty. And so if you plead guilty, I could, after I've heard all the information, decide that's not the correct sentence, that you should be sentenced to a prison term between 6 and 12 months and fined $2,500. You understand that?
Yes, Your Honor.
Right now, do you hold any license or certificate from any state agency that regulates any occupation or profession?
No, Your Honor.
Right now, you have certain constitutional rights, because understand before I can accept your plea, first you have a right to have an attorney to represent you. I appointed Ms. Barton. Now, that appointment wasn't simply to work the case out, but provide any defense might be available to you under the law that you would wish her to provide. So, if you decide you don't want to do this, you want to stand on your not guilty plea and defend against the charge, she'll continue to represent you, including a jury trial, if that's what you want. You understand that?
Yes, Your Honor.
Right now, under the law, you have a right to have a jury trial in this case, in which 12 people would be selected from a group of citizens from this county, selected for jury duty under a trial. After they are selected, the 12 jurors will hear the evidence and be instructed on the law. Then that jury would decide by a unanimous verdict, meaning all 12 would have to agree, as to whether or not the state proves your guilt by proof beyond a reasonable doubt. Now, okay, hold on here a second. I have a situation here. I need to take a quick break. Okay, I apologize for that. I'm here at home with my wife, and she's not able to get up, so there's somebody at the door. All right. Okay, I believe I was talking about the jury trial. That you have a right to have a trial by 12 jurors selected from this county, from a group of people that are summoned for jury duty on your trial date. And then after all the evidence was presented, the instructions of the law, they would decide by unanimous verdict, meaning all 12 would have to agree on whether or not the state proves your guilt by proof beyond a reasonable doubt. You understand that, Mr. Wilson?
Yes, Your Honor.
Right now, under the law, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else that's present for the trial. After the prosecutor's done asking questions, your attorney has a right to ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. You understand that?
Yes, Your Honor.
Right now, under the Constitution, Mr. Wilson, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to be able to come in voluntarily, at your request, the court issues a subpoena. That's a court order that would force those people that you want to come to court to testify for you to be there, testify, even though they don't want to be there. That's the same way the state's witnesses are forced to come into court. You understand that?
Yes, Your Honor.
Right now, Mr. Wilson, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence against yourself in this matter at any time. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. But if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to talk about it or to mention it, with one exception. That is, if there's a jury trial and you don't testify, the judge does instruct the jury And because that's your right, they cannot consider it for any purpose. You understand that?
Yes, Your Honor.
Right now, under the Constitution, Mr. Wilson, you are presumed innocent until proven guilty by the state of Ohio on every element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused of this offense. In fact, under the law, you're not required to even present any evidence in your defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged. The highest burden of proof is known under the law. You understand that?
Yes, Your Honor.
Now, originally entered plea of not guilty, Mr. Wilson, which denied the allegations in the indictment, denied you committed any crime, and exercised or revoked all the rights that I just described for you here today. If you change your plea from not guilty to guilty, that's the opposite of not guilty plea. Guilty plea admits the allegations in the indictment, admits that they're a crime, and that you're the one who committed that crime. That plea would waive or give up all the rights that I just described for you here today, except the right to have an attorney, because you always have the right to counsel, no matter what your plea is. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you and to cross-examine through your attorney, would waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state, would waive or give up your privilege against self-incrimination because you're the one saying you're guilty, that's what finds you guilty, waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. If guilty also waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, should you be sentenced to the maximum sentence or under certain circumstances you can file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. And finally, a plea of guilty subjects you to be sentenced immediately by the judge if that's what I determine is the right thing to do. Do you understand that?
Yes, Your Honor.
And are you a U.S. citizen, Mr. Wilson?
Yes, Your Honor.
All right, now, Mr. Wilson, do you have any questions about the charge and the possible penalties?
No, sir.
You understand?
Yes, Your Honor.
Do you have any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes, Your Honor.
Do you have any questions about the constitutional rights I've explained to you?
No, Your Honor.
You understand those?
Yes, Your Honor.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, Your Honor.
You understand that?
Yes, Your Honor.
Now, is there anything you'd like to speak to your attorney about before we go any further? If you do, I can put you in her into a breakout room where just the two of you speak below and no one else will see or hear.
No, Your Honor.
Have any questions at all about anything that we've done here this afternoon in your case?
No, Your Honor.
All right, then, Mr. Wilson, is it your decision to withdraw your non-guilty plea, plead guilty to the charge in the indictment, pursuant to the terms of this plea agreement that we've just done?
Yes, Your Honor.
Okay, then as to the charge, it's alleged that on or about July 17, 2021, in Hyden County, Ohio, you did with purpose to deprive the owner, Shirley Blevins, of her property, did knowingly obtain or exert control over said property to win $3,200 U.S. currency, and other miscellaneous items by deception, and the value of that property being greater than $1,000 but less than $7,500. Violation of section 2913.02A3 of the Ohio Revised Code, charged with that by deception, a 5th-degree felony, and possible prison term between 6 to 12 months, fine of $2,500. How do you plead?
Guilty.
Right. Court finds on this date of the court, as advised of all the constitutional rights made knowing tough voluntary waiver saying that Rule 11, please accept an order filed. Defendant is not guilty of the charge. As set forth in the indictment, the matter will be referred to the prosecutor to the probation department for a pre-sentence investigation under the same bond. Do you need his contact information, Mr. Fulton, or is he?
He's in our office now.
Oh, okay. All right, no problem then. All right. The sentencing will be, the PSI will include a assessment for substance use and disorder treatment and or mental health. And sentencing will be at 2:15 on January the 6th, 2020. That will be a Zoom hearing, otherwise notified. All right. Is there anything further from counsel?
No, Your Honor.
Any questions, Mr. Wilson?
No, Your Honor.
Okay, since you're already there in probation, they'll talk with you.